Hi everyone, this is Urvashi Rathore, a law student, daughter of an advocate. So pretty much my entire life I have been associated with law and I've been fascinated with law. This is a YouTube channel which I'm starting. I'll start by teaching very basic concepts, and you can ask me any questions in the comments and I'll answer those questions. But since this is the first video, we'll keep it light and we'll start with the Indian Penal Code and its most talked about sections, which are section 299, 300, I could say. So this is murder versus culpable homicide. Actually, this is wrong. Do you know, murder and culpable homicide are not two different things? No, it's very technically wrong if somebody is saying murder or culpable homicide, because murder is a part of culpable homicide. So culpable, imagine this, culpable homicide is a wider term, and then it is divided into two parts. One is culpable homicide which is amounting to murder, and another culpable homicide which is not amounting to murder. So these both terms, where culpable homicide is amounting to murder, we call it murder, simply murder, and the culpable homicide not amounting to murder, just for I think easy, or it has become a language something, so we just call it culpable homicide. But actually culpable homicide is this, it has two bifurcations. So what happens is, what is culpable homicide? It is aparadhik manavvad. Like if you have killed someone, and when killing someone becomes an offense, that is culpable homicide. Like if you have killed somebody in private defense, it won't be culpable homicide. But if you have to take out revenge and you kill somebody out of the rage of that revenge, it will be culpable homicide. Now then you have to decide, will it fall under murder category or culpable homicide not amounting to murder? And why is it so important to bifurcate two things? Why couldn't they just have one thing? If you are killing someone, let's call it murder. Because look, law should always make sense. If something you are reading and it's not making sense to you, that means you are not reading it correctly or properly, because law always makes sense. It's common sense basically. So the reason what I have read and so many cases and everything, I feel is like sometimes in the rage of the situation, or where person is not properly planning to kill someone and that person kills someone, and there's another situation where a person for years planning to kill someone, and then he or she goes and kill the other person. These two are different situations, and for these two situations there should be a different punishment. That's why I think culpable homicide has been divided into two parts. Now in easier words, we know culpable homicide is when you are killing someone and that killing amounts to an offense. It is culpable homicide. So there are three essential elements for culpable homicide, like for an act to come under the category of culpable homicide. One is, if you do an act with the intention of killing someone, it is culpable. Like intention of killing someone, first element. Second is, your intention is to cause such bodily injury. You are saying, no, I didn't fire, I just threw an hammer on that person, right? So your intention is to cause such bodily injury that the person will die because of that bodily injury. So indirectly he's dying because of And third is where you have knowledge. Sometimes it becomes very tough to prove the intention. So even if you don't have intention, but you have knowledge that if I'll do this act, then this person is likely to die, right? You have this knowledge. So then if you have a knowledge and you still do an act which will likely to cause and death of some person, then that will come under culpable homicide. Now if act falls in any of these three categories, then this amounts to culpable homicide. Now we'll divide what kind of culpable homicides become murder. So for that also there are four conditions are given, and then in that after that four condition, exception to those four conditions become culpable homicide not amounting to murder. So we'll talk about first amounting to murder. So we have read this part, which culpable homicide. Now we are going towards this part, which is basically murder. Sorry for my imaginary drawings, but yeah. So it has 4 rules. When directly, of course, if you are killing someone with the intention, we are doing an act with the intention of killing someone, then that culpable homicide comes under the category of murder. Second one is, the offender knows that such bodily injury can cause death. So now this is a bit tricky one. I have a head injury, right? If somebody tap me here, I will not die, right? Like little harder or with somebody, I might have injury, I will not die. You don't have knowledge that this person will die. But just imagine I just had head surgery. Here I have stitches and doctor has told me that if even if you there will be a little pat here, that will be very dangerous for me. I am talking about the second condition. So if somebody who wants to kill me and that person knows, okay, right now she had surgery, and if I do anything on this part of her head, she will die. In normal conditions it won't be sufficient, but in this condition this is sufficient, right? So if that person comes and just tap me very hard here or slap me on the head and I die, then it will also murder. So these are the conditions we are discussing. One thing you need to understand, the basic idea behind putting these conditions is this: murder is basically where you actually wanted to kill the person. You have planned in our head and you are either killing that person directly or just killing by some injury where you know that this injury or this is very sufficient to kill that person. So then the drafter has divided in such condition that all kind of situations come under this, and there would be no loophole. So second condition is like, the offender should know that such injuries can cause death of that person. To save from those loopholes, the second condition is there. And the third one is, act done with intention to cause bodily injury plus injury is sufficient to cause death. Second is like, you have caused such injury which is sufficient. It's not like likely and sufficient are two words. Likely is like there are high chances of something happening, and sufficient is, you know, definitely this person will die, right? So if you are causing such injury that you know because of this injury this person will definitely die, this is sufficient to kill that person, this also comes under murder. And fourth one is, you are doing any act, you know, in all probability, I don't know why, any method you are doing such act which you know definitely kill that person, right? So that is murder. We were discussing like 5 exceptions which will put this murder which will shift the act from the category of murder to culpable homicide not amounting to murder. What are the 5 exceptions? First one is provocation. So if some act is done and one person kills another person, but the initiator of all these things was in a provocation, was in an act which provoked a person up to the extent that the person has done in the rage of the moment or whatever, an act which have killed another person, comes under this. Now one very important thing, if you see or if you understand, is that provocation should be enough. You can't take the defense of provocation if it was a small thing. If somebody said some bad word to you, you can't kill that person and say, okay, this defense, I would lie under this defense. No. The provocation should be big enough. And if you know, there's a very very famous case, KM Nanavati, where they tried to take defense of provocation, and in the end it didn't happen. We'll discuss that case someday later, but some other day. But yeah, so provocation should be sufficient enough to kill the person. You should not be, not A. If A killed B, A shouldn't be the person who have started or initiated this whole transaction because of which the other person provoked this person, okay? So your act shouldn't end up in making that person provocate you. Secondly, and thirdly, if somebody is doing some legal act or something which is correct and you are getting provoked because of that, if public servant is doing his duty and you are getting provoked because of that, then this will also not come under this. Easy one. Second is private defense. So in private defense, there are conditions where we, for the sake of private defense, we can kill the person, okay? But there are situations where you can't. So again, here comes the common sense. If somebody has taken your under the theft, if they were running, they took your some valuable item, they were running and you caught the person and you took the valuable item, first of all your private defense ends here. And secondly, even if in the process of taking the item you can't kill someone, right? There are situations for in which it is defined where the under private defense you can kill someone for the body or for the private defense for the property. So other than those situation, if you kill someone, you can't take the defense of private defense, which is in 96 to 106, then that will come under culpable homicide. But yeah, it could, when you extends your right to private defense, when you exceeds, actually not extends, when you exceeds, then yeah, it will come under culpable homicide not amounting to murder. Third one is like public servant. So culpable homicide is not murder if the offender, being public servant or aiding a public servant acting for the advancement of public justice, exceeds the power. Yeah, so basically public servant has to do their duties, right? They have some powers to keep the peace and for the help to help the people. So it is saying when you exceed your power, similar to private defense. In private defense you have the power to take the private defense, but you cannot exceed it. If you exceed it, then it comes under this category. So as a public servant you have some duties, you have some powers. If you do this, then it's fine. But if you exceeds your power and then kill someone in that transaction, then it comes under this category. Fourth is heat of passion in sudden quarrel. If suddenly a fight happened or some very serious quarrel happened, and then in that heat if you kill someone, then it comes under the fourth exception. Fifth exception is like if somebody has given you consent to kill them, right? It doesn't make it non-culpable homicide, right? It will still be culpable homicide, but it won't be murder because you have not been planning to kill that person. Your intention was because that person said, but from your side you didn't want it. It's the other person who has given you consent, and the person should be above 18 years. It's very important. If the person who has given consent is under 18 years, then it will come under murder. It won't come under culpable homicide because person under 18 years is not capable of giving consent for such situations. So yeah, culpable homicide. Then we have talked about the 4 conditions which makes that culpable homicide murder, and the remaining comes under culpable homicide not amounting to murder. So in this 5 exceptions come, and if you are coming under if somebody is fulfilling these 5 exceptions, then this comes under culpable homicide not amounting to murder. So yep, do read these things. Law is very interesting. Do read these things and let me know if you have any questions. Comment in the section. If you didn't get any part, I'll try to make you understand that thing, give you example. They are so interesting case laws, and everybody should read KM Nanavati. And yeah, thank you guys.